Bail is considered a normal right under criminal law. If a person is accused of offences except murder, he or she can get bail. But under the UAPA, the Unlawful Prevention of Activities Act, bail is a near impossibility. And the reason is that it's a counter-terror law, now a permanent counter-terror law, that makes it very, very difficult for any person to get bail. Remember, it was this law under which Jesuit priest and tribal activist Stan Swami had been incarcerated. He spent 10 months in Taloja jail, tried from May 2021 onwards to get medical bail. Unfortunately, got it at the last moment. He was suffering from COVID, and finally, after he got medical bail, a little late, he succumbed on July 21st, 2021. The use of the UAPA as a law in certain charges actually serves two major purposes for the investigating agencies and the police. First, it doubles the amount of time they are granted under the statute itself to file a charge sheet. Normally it's 90 days, under UAPA it's 180 days. Second, if terror offences are invoked against an accused, Section 43D5 kicks in. So Section 43D5 of the Act states that if a person is accused of terrorism offences, he or she shall not be released on bail if the court, after perusing the case diary and the charge sheet, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Now, in layperson's language, what does this mean? It means that if the court, presented with a bail application by an accused under UAPA, where 43D5 has been applied, comes to the conclusion that what the police has stated in the case diary and in the charge sheet is prima facie, that's on the face of it true, then the court cannot under the law grant bail. Never mind the fact that we all know that in most cases or many cases, the police, NIA and UAPA cases actually files case diaries and charge sheets without any rigorous investigation, without testing evidence, and often based on political and partisan orders. This 43D5A has also been interpreted in certain ways by the constitutional courts. Unfortunately, in 2019, the Supreme Court itself, while looking at one case under UAPA, came out with a pretty rigid interpretation of this section. The case was 2019 National Investigation Agency against Zaroor Ahmad Shah Watali, and the Supreme Court overturned the Delhi High Court judgment that had granted bail to a Kashmiri businessman. This is the same Watali judgment which is widely cited now, since 2019, denying bail to accused under UAPA at any stage of the trial. Never mind if it's 6 months, 2 years, 5 years, stating that the allegations against the accused are prima facie true. Now, what was the Watali case? In NIA versus Zaroor Watali, the accused Watali was a Kashmiri businessman who was charged for acting as a conduit for transfer of funds received from a terrorist to a secessionist leader and for helping them to quote-unquote wage a war against the government. His bail was rejected by the special NIA court, which came to be reversed by the Delhi High Court. The High Court judgment, Delhi High Court judgment, authored by Justice Muralidhar, was a welcome one, which acknowledged the high burden of proof that was placed on the accused in such cases and how the UAPA made it nearly impossible to get bail. One thing I need to mention here is that there is nothing to compel the NIA or the police in such cases to ensure that even the 180 period for the charge sheet is met. There are cases in which months and years on end the charge sheet is not filed, which means that bail is denied ad nauseum endlessly. The Delhi High Court judgment by Justice Muralidhar infused a sense of fairness into the process by establishing and requiring that it is the courts that would assess the reasonableness of the case, not the NIA or the police that would assess the reasonableness of the case against an accused. Watali was a judgment authored by Justice Khanwilkar. The apex court held in that judgment that the Delhi High Court's judge was inappropriate. The Supreme Court in 2019 in this judgment added that at the stage of bail, the court wasn't required to weigh the evidence against an accused. It was only supposed to look at the material provided by the investigating agency in its entirety and to see if it was prima facie true. So in a sense, the independent jurisdiction of the court to look at evidence outside the gaze of an investigating agency or the police was itself whittled down by the Supreme Court in this judgment. So result, no UAPA accused could really get bail until this judgment held. The implications of the observations made in the Vatali case could be seen in the bail petitions of the 16 academics, lawyers and activists arrested in the Bhima Koregaon case. Arrests, as we know, a spate of them began in 2018 August, 28th onwards. And multiple youth leaders and scholars after that have been incarcerated under this draconian law. Anti-CAA protesters in 2020 also have been in Tihar jail under this law. Many in Uttar Pradesh too are jailed under this counter-terror legislation. But post-Vatali in 2019, there has been some hope again from the Supreme Court. Despite the worrisome implications of this order, the Supreme Court has itself played a role in trying to reinterpret and widen bail, the scope of bail under UAPA post-Vatali. In another case, Union of India versus K.A. Najib, which is a 2021 case, the centre had filed an appeal against the July 2019 order of the Kerala High Court that granted bail to accused who had been in jail since 2010. Now, these accused were PFI, Popular Front of India activists, and they had been accused in that ghastly case of the professor's fingers being chopped off. And due to the long period of incarceration, they had been granted bail by the Kerala High Court. The Supreme Court had dismissed the appeal against the High Court order. That was one ray of hope. The Delhi High Court actually set a really interesting precedent in June of that year, that is in June 2021. When it granted bail, lead judgment was Asif Iqbal Tanha and Devangana Kalita and Natasha Narwal. These three prominent student activists, as we know, had been jailed for the anti-CAA protests of 2019-2020, and they were being accused of being masterminds behind the Delhi violence. How their involvement in a protest could ever be a terror act was of course a shock to many of us, but when the court had made very important and interesting observations relating to the fundamental right to protest and how the right to protest and the rights of the police in terms of preservation of public order cannot be confused with the Terrorist Act. In 2022, P.V. Varavara Rao versus NIA, the very renowned Telugu poet, was granted bail on health grounds by the Bombay High Court. When again the High Court, using the Najib case, citing the Najib case, said that the restrictions on bail under UAPA have to be harmonized with the jurisdiction of a constitutional court to be able to assess independently whether investigating agencies and police are acting independently, thoroughly and fairly. Many others, academic writer Anand Teltumbe, Siddiq Kapan, Akhil Gogoi, Ishrat Jahan, Arun Ferreira, Iqbal Ahmad Kabir Ahmad have all been granted bail under UAPA since then, but after several months of incarceration. And bail in all these cases has somehow meant a slight breakthrough in widening the jurisprudence of bail under UAPA. Unfortunately, and this week was 3 years of the incarceration of the well-known academic and student young leader Umar Khalid, there are many others like Mahesh Raut, Jyoti Jagtap, Umar Khalid, Sharjil Imam, Asif Sultan, Fahad Shah and Gulfi Shah Fatima, all still incarcerated under UAPA. The Vatali judgment today has not completely yet been reversed by the Supreme Court. The scope for bail has been certainly widened. So what do we do to raise our voice against such a draconian counter-terror law, particularly where the entire control of granting bail appears to be in the hands of investigating agencies like the NIA and the police? Often these investigating agencies themselves are beyond scrutiny. How long will the struggle, the constitutional struggle, to get a draconian law like UAPA be repealed continue? How many years will innocent academics, political prisoners, etc. remain incarcerated? And what will it take for us to snatch our fundamental freedoms back?